Today we're going to talk about what your rights are if you are not married to the father. There are so many questions when you're a single mom. What if the father is listed on the birth certificate? Or should you put the father's name on the birth certificate? Or does it even matter? What if the father does not return the child? What can I do? Florida Statute 744.301 states that the mother of a child born out of wedlock is the natural guardian of the child and is entitled to primary residential care and custody of the child unless the court enters orders stating otherwise. Well, what does that mean? Well, that means exactly what it says. Under this statute, the mother has a superior right to custody of the child born out of wedlock until the action is brought in circuit court to establish paternity. When the father is listed on the birth certificate, it creates a presumption that the father is the biological father. But having the father listed on the birth certificate does not give the father a superior right to custody and control of a child born out of wedlock. In fact, it does not automatically convey any parental right or duty to the father. When the parents are married, both parents have equal rights to the physical custody and control of the child born during the marriage. However, mothers have a superior right to custody and control of a child born out of wedlock, regardless if the biological father is on the certificate. Now that we learned about that superior right, it's also important to remember in Florida, regardless of the superior right, it is also the state's public policy that both parents have continuous and frequent contact. It's important for unwed mothers to understand the importance of establishing a consistent and continuous schedule to establish strength and to nurture the parental bond with the child and the father, as well as with the mother and the child. Under Chapter 744, under the Natural Guardian Statute, in the event you have a child out of wedlock and the court has yet to enter any order establishing time sharing, even if the father is known or the father's name is on the birth certificate, the mother has a superior right to custody and control of the child born out of wedlock. If the father takes the child and refuses to return the child to the mother, upon motion to the court, the mother may be entitled to an order to pick up the child with the assistance of sheriff if needed. If this happens to you, you need to talk to an attorney. Call for a free consultation and an explanation of your parental rights. Tune in next time for a discussion on how unmarried fathers can establish and enforce their natural parental rights. Every case and circumstance are not the same. This video is for general informational purposes only. If you need legal advice regarding your individual circumstance, please call an experienced attorney in your area. This video does not create an attorney-client relationship.